Okay. Thank you so much. Am I audible, Director?
Yeah, yes, you are audible.
Okay, you know, when you're in these sides of Mashinani, we have to check. So, good evening, everyone, and thank you so much, our host, our director. My name is Cherono Daisy Kerich Karaoke. Daisy, as the director has said, is a counseling psychologist and also an internationally accredited mediator and a court annexed mediator working in 8 courts. I work in Milimani Law Courts. I work in Bomet Law Courts, Naivasha Law Courts, Nakuru High Court, Nyeri High Court, Eldoret High Court, Kapsabet Law Courts, and I think the final one, which is the newest in the block, is Cabernet. So number one is to appreciate all of us for joining together with the entire team of Mediation Africa. Together with our director, thank you so much for organizing such a wonderful webinar. I will go straight to my presentation. I will ask questions, and through these questions, we can just respond through the chats because, as you can see, the history of mediation. I know there are some who are joining us purposely so that we can help them resolve their disputes. And there are those who are joining us for purposes of also wanting to be trained as mediators. So that is very fantastic. So the first question I would ask is, according to you, is conflict good or bad? Just respond in the chats so that we can have a rough idea what conflict means to you. Is it a good thing or a bad thing? Just respond to the chats. As I'll be checking, okay, there's a good,
Yes.
thank you. Bad, thank you very much for your responses. Victoria says good, Thank you so much. Bad, awesome. Let's keep on. Good, bad, You're wonderful. You know, when you're a trainer, the first thing I wanted to test is, are we together? So there's both, Wonderful. So that is great. Ludia says it is two-way. It can either be good or bad. It's both good and bad. It's both. Awesome. So at least from the responses, thank you so much, wonderful people. At least from the responses, I can see there's somebody who says conflict is bad. And Chebet says both. Thank you so much. Those are wonderful responses. We can just pause, but thank you so much. From the 76 responses, I would say that is fantastic. Fantastic. Now, let us help each other from this point. 82 responses. Clap for yourselves because this is good feedback. So, conflict depends the way you view it, because conflict is as old as humanity. There was even conflicts from birth, and also we'll entirely have conflict until we die. Because number one, we find ourselves interdependent. You depend on me, I depend on you, and so at some point we might clash. And in this clash, we can have a conflict. So for me, I would say conflict is good and bad, because conflict will enable me to know what are my strengths and what are my weaknesses. So in this, I can be able to say, indeed, conflict has made me a different person. I like giving my example. When I was trained as a mediator in 2018, I had encountered so many conflicts, both intrapersonal conflict and interpersonal conflict, because there is conflict within and conflict without. So the conflict within is conflict that you're battling within yourself, intrapersonal conflict. And sometimes you find yourself competing even with others, yet this is an intrinsic thing. So you compete with other people, you get angry with other people, so you transfer that, and that forms now what you call interpersonal conflict. So when you learn how to maneuver and resolve conflict, it means you grow out of this conflict. So it means, for me, I knew that I needed to do something about conflict so that I can help myself out. So I worked on myself, and I remember receiving a letter from one of the councils. That time, I would say I was not really well equipped to handle conflict. I used to just get annoyed very fast. And I told my neighbor by that time, I told my neighbor, you're a very bad neighbor, blah, blah, blah. So I got a letter from the council indicating that if you don't apologize within this period, we will file a case in court. So by that time, I was very naive. I had no idea about the court process. I did not know kuambia mtu kwenda was a bad thing. And so it almost costed me. And that is when I heard about mediation and I was like, what is mediation? And I went in and studied the course. And from then I got real transformation. And I understood that conflict was bad, but now it has made me to be a better person. And so it has even made me to be a good person in terms of relating with other people. And so when we look at children and family, I say I'm very passionate about conflicts regarding family matters. I just closed a case of a family dispute on Thursday in Bomet Law Courts. And the family they were scattered because conflict had made them to be in very bad loggerheads with each other. And I remember after resolving the session with them, the matter with them through mediation, they were like, wait, kumbe conflict is good because it helps us to grow. It helps us to know that this is workable, this is within my boundary, and this is not within my boundary. So again, I would say, in terms of conflict and religion, conflict with God, conflict with first human conflict was conflict between man and God for disobeying. So you find that we are in conflict because of what happened from the genesis. From the beginning, there was conflict. And so in Kenya, mediation was brought into record through our Kenyan Constitution, Article 159 2C. Mediation is an alternative way of resolving disputes. How do we resolve these disputes? If you have any family disputes, we can be able to work with you. We can be able to mediate your case. And so in our Kenyan Constitution, Article 159 of the Constitution, it tells judiciary to promote alternative dispute resolution mechanisms. And so mediation has been pegged as one of the ADRs, alternative ways of resolving disputes. And I will tell you, it is the best among the other listed ADRs in our constitution. We have an ADR called reconciliation. We have another ADR called arbitration. We have another ADR called alternative dispute resolution mechanism or traditional dispute resolution mechanism. So you find that when we talk about mediation in our Kenyan context, it is supported in our Kenyan Constitution, Article 159. So we encourage all of us, please come and let us help you resolve your dispute in an easier manner. Court annexed mediation. What really happens in court annexed mediation? Court annexed mediation, if you have any case pending in court, as long as it is not criminal in nature, kindly, I would tell you, and kindly, let us have the matter. You request the court. You tell the court that we would want this matter to be handled through mediation. You do not pay the mediator. The mediator is paid by the judiciary. So you simply request the mediation deputy registrar to allocate your matter to a mediator. And so the mediator helps you to work with you in terms of facilitating the process, and you manage to resolve a dispute. Just like the one I've mentioned that I managed to resolve the family matter that was pending in Bomet Law Courts. Bomet Law Courts is the leading, and I'm the chair of Bomet Mediators. And I'll tell you, when you embrace mediation through court annex mediation, it is the best. For private mediation, what private mediation means, and that's why we are here today, is that there are those cases that have not gone to court. You're planning to take the case to court. I would tell you, my dear one, please, right now, we have a backlog of 336,000 cases pending in court. The beauty is there's an additional list of judges, 20 of them, that were appointed the other day. But the reality is, imagine 336 cases versus the one of 5 judges that we had. How long is it going to take for every judge to listen or magistrate to listen to your case? So I'll tell you, you'd rather try the private mediation. Private mediation means, as a mediator who is already accredited, or even the one that has already been trained, a trained mediator can handle a dispute or can help you resolve a matter and then later on take it to court for adoption. So what that means is, after your case has been taken to a private mediator, a mediator who's already trained or already accredited, the first thing is they will listen to your issue. They will walk with you through the journey of mediation. And later on, if you get an agreement, a full agreement, now that agreement will be an order of the court. The mediator takes this agreement to the court for adoption by filing an affidavit and also attaching the agreement, the agreed points in the court. So that sums up your private mediation, and it becomes an order of the court. You did not go to court, but you resolve your matter through private mediation, and the mediator took it to court for adoption. And finally, mediation in the global space. This is my favorite part. I was trained as an international mediator last year, and after being trained as an international mediator, right now I'm pursuing the global space. Why the global space? There are very many opportunities for mediators to be able to resolve matters of even other countries in the global space. So if you're here and you're interested in being trained as a mediator, you want to join us, please join us as we also explore this global space. The UN, if you Google, the UN are looking for mediators. Also, these other institutions like Weinstein International Foundation, who are our sponsors, you become a fellow through being accredited first as a mediator in Kenya. So there are very many opportunities for you outside there, both in the global space and also locally in Kenya. As at now, I think the Mediation Accreditation Committee has accredited 1,515 mediators. What does that tell you? Can you imagine the population that we have in Kenya? Almost 50 million plus. Currently, as a mediator, I have like 6 matters pending. I had 7, but I concluded one on Thursday. So I have 7 pending matters, which is back to back now. So I'll tell you, there's a lot of opportunities. Please seek these services. When you can, we'll be able to help you out. So I would stop there because of time. And thank you so much. Back to you, Director.
Thank you very much, Daisy Cherono. She is the number 2 mediator in settling matters in Kenya. That is from a statistic that was released from the judiciary just the other day. In summary, what we are talking about is how to win in mediation. Daisy has taken us home to understand what mediation is, a brief history of what mediation has been since humanity to now. This is a timeless career. We were born in conflict and we will die and live conflict. So if you're looking for an opportunity to get that career that is an endless one, ile tunasema without retire, this is your opportunity. Good thing is that it is recognized by the judiciary and it can help you earn a living, either part-time or full-time. But in this case, we are talking to people who are in dispute. You don't have to cry or go through that very hard time by yourself. I think we have experts who are able to help you resolve your conflict amicably and in a better way and in a formal way and in an enforceable way by the government. Now, having said that, there are a lot of demystifications that go with mediation. We want to demystify what mediation is and what it is not. And to help me do that, we shall have Dr. Alice Gikandi demystify what mediation is and what is not. Dr. Alice, kindly put on your camera and unmute. Wonderful, Daktari. Karibu sana. Please take us through what the mediation is not.
Okay, thank you. I thank everyone for joining us this evening. And as director has introduced me, my name is Dr. Alice Gikandi. I'm a consultant psychologist. I'm also a mediator. I have a passion for mediation, just like I have a passion for psychology. And because when I see two people that were battling, agree and smile at one another, it's very fulfilling to me. And it's a good thing. It's a good thing. I'm telling you, it's a good thing when you find people at peace. I do mediation at the High Court. I'm also a mediator at Kiambu, a mediator at Machakos, Roiro, and Gatundu. Yeah, that's where I do my mediation matters. So my portion, as the director said, mine is to demystify mediation. And mediation does not necessarily mean reconciliation. Those two terms are different. Reconciliation is when two parties repair their relationship. Here, the differences between the two are settled. It's a good thing to reconcile, but mediation does not necessarily mean reconciliation. But if the parties decide to mediate and even reconcile, is good enough, but the two are two distinct processes. But now here we are dealing with mediation. And in mediation, just to put the distinction, is when one party tries to help two other parties repair their relationship. This is the process by which a mediator facilitates two parties to arrive at a settlement of their dispute. A mediation settlement is the outcome of the mediation process. A mediation settlement agreement is a significant piece of the contract that helps in dispute resolution. A mediation settlement agreement is a document created after successful mediation. It is a binding contract that outlines the terms created after successful mediation. It is a binding contract that outlines the terms and conditions of the dispute resolution reached by the parties. So it is the end result where the parties have now agreed that they have reached an agreement and their dispute has been resolved. The agreement also ought to be signed by the parties in dispute. It will include the issues that the parties have agreed on, because they must be clearly stipulated. It will then state what the parties have agreed to do in order to settle the case. That must be very clear. The agreement will also say what the parties will do and when they'll do what they have agreed to do. And it's good to note that if one of the parties fails to do something that they're supposed to do by the terms of the agreement, the other side can go to court. They can ask the court to order the party to abide by the settlement agreement. And we have different types of agreements. And one of them is where you have a full settlement And this is where the parties have been able to agree the settlement whereby disputing parties arrive at a mutually acceptable agreement. The parties here will agree on all the issues in the dispute. Like, to explain, you may have had 5 issues, like what we are discussing today, issues of children. Maybe there'll be custody, there'll be who will pay the medical insurance, will pay the school fees, and such other things, you know. There's also what we call the partial agreement. And this is a partial agreement covering only a few of the key issues. The parties maybe were not able to agree on all the issues in dispute, but they've been able to agree on a few. Maybe 3 out of 1 or 2 out of 2 is still a nice thing. And when it is a partial agreement, it means that the parties will seek the court determination on the matters not agreed upon. The 2 matters that remain outstanding, you can seek the court's indulgence. There is also non-settlement, which is still allowed. This is where the parties to a dispute do not agree, and it means that the parties wish to have the matter referred back to court for determination. This can happen. Sometimes the parties may say, for this, our matter, we'd rather go back to court. And it's still allowed because mediation is a voluntary process. Nobody forces you. So if you don't want to mediate, remember, you can always go back to court. There's also the aspect of non-compliance. And this is where the parties it involves dealing with a party who non-compliance. It involves dealing with a party who fails to comply and adhere to the mediator's directions, and consistent non-attendance of the mediation sessions, or engaging in deliberate misconduct with the requirements in the mediation process. And this could be interpreted as contempt of court. It can happen, but it's a serious matter where parties do not comply. You better come and say what is it in your mind. But if you don't come, you've been asked to come and you disobey, it can be treated as contempt of court. And is usually given when a party fails to attend mediation sessions, hindering the progress of the mediation sessions, or failure to adhere to mediators' directions, consistent non-attendance of the mediation sessions, or engaging in that what you're calling deliberate misconduct. So there are those that, when you're dealing with people in dispute, it is a difficult matter, and there could be issues of non-compliance. So basically, that explains much of the mediation process. But of course, this is just a small portion. If you want to train with us so that you can learn more, or you have a matter that you would wish to refer for mediation, we are here for those 2 purposes. Thank you so much for listening to me.
Mm-hmm. Thank you very much, Dr. Alice. We truly appreciate your input in this matter. In summary, she has said that mediation is not reconciliation. So in essence, we're not saying you go back to an abusive husband or you go back to an abusive wife. In the event that those you cannot be able to cohabit, we are saying that if and you agree to stay apart, that is still some sort of a settlement. And that is the one that we are saying we have agreed to disagree. In fact, Sharono normally brings that out very well. We have agreed to disagree. But even in that position where we are saying we have agreed to disagree, there could be children, there could be responsibilities that need to live. Life does not stop just because people have a disagreement and they have agreed to disagree. All those things, the children will still need to live. They need to go to school. They will need medical attention and all this. So if that is the case, then who takes care of what responsibility? And like Daktari has said, there's something called a full settlement that we have agreed on all things. that we were planning, we were talking about, mtoto ataenda shule fulani na atalipiwa school fees na nani, na hiyo story imeishia hapo. But there is also something that is called partial settlement, where I might be able, my lady might want the child to go to school A, B, C, D. I do not want to mention so that they do not quote me. But in my capacity, I can only afford school A, B, C, X, Y, Z. My wife wants A, B, C, D. I can afford X, Y, Z. So from there, where do we go? Hapo pia tunahitaji usaidizi. So it means that we have partially agreed that the child can go to school, but wapi na ni nani analipa, hapo imekuwa ni tashwishi. So we can go back to court and the court can help us decide on that. There is no agreement. There's also an alternative of no agreement. Hatutawahi elewana na tumeagree hatutawahi elewana. So of course, like Daktari has said, mediation is voluntary. So kama hatuwezi kuelewana, then we go back to court, tupigane huko for as long as we can, and then sometimes it doesn't come out. Most of the time, it will not come out the way you would have wished for it to. And again, winner, I mean, kukiwa na winner na loser kwa marriage, kwa kushughulikia watoto, is not the very best scenario. The final one is non-compliance. And non-compliance is unaweza niita kotini na nikatae kukuja and I don't care and I do not care and there is nothing you can do about it. Those are still types of settlements. But as Daktari has pointed out, mediation is not reconciliation. That is just a perception. Mediator si mpatanishi. Mediator is just an expert who helps you to bring things together. Now, Daisy and Alice, I don't know, I have not still seen Nancy Wairobi. She's a chartered mediator, but because she's not here, and I really want to take, but if you see her, please let me know. And we don't have time, and we have a quorum of about 213 persons online. I don't think it is fair to keep them waiting. So I'll take you through what the winning strategy in terms of mediation is. Sasa kwa sababu watu wanapigana, if we are in conflict, I need to know what is my winning strategy. Sorry, Daktari, you wanted to say something?
She's there. She's there.
Where is she?
Nancy,
please. Nancy, please raise your hand so that I can be able to see you. Mediator Nancy, I am not able to see you. Oh, yes. I've seen you here. Sorry, I apologize for that. All right. Nancy is a chartered mediator, also working at the High Court of Kenya, and is also on the eastern part of Kenya. Nancy, kindly take us through the winning strategy in mediation.
Okay, good evening, everyone. Can you hear me, Director?
Yes, I can hear you loud and clear.
Wow, thank you. I'm sorry for for missing me so much.
Yes.
Let me start by appreciating our participants and welcoming them on board. As you have heard, I am Nancy Wairobi, a chartered mediator based at the High Court, Nairobi, Milimani, Machakos, Kajiado, Murang'a, Mavoko, and I'm both a professional counselor and a chartered mediator and a mediator trainer. And now in mediation, we handle different issues or different areas of mediation. We have family mediation, commercial mediation, land dispute mediation, labor dispute mediation, any area, think of it, and any area where conflict can be generated, mediation will work. The only areas that we normally do not cover is criminal cases. Those ones, we leave them to be handled by the court. So when it comes to mediation, there are different reasons why people will find themselves in conflict. It could be the properties that they are fighting over in succession matters. It could be contracts which have not been honored. It could be labor where either you have been laid off unceremoniously or you feel it is not right for that. Today,
Hello, Dr. Nancy. I think Nancy's network has a bit of an issue. Dr. Alice, can you hear her? Dr. Alice, can you hear her?
No, I can't hear her. She's lost.
Okay.
We've lost her. We've lost
her. All right.
Yeah.
Okay. Okay. All right.
me now, Dr. Ari.
Hello.
Yes.
Yes. Okay. Oh, your network is a bit unstable, Nancy.
So can you hear me now?
Yes, we can hear you.
No, there was a disruption from an incoming call.
Okay.
Yeah, otherwise, okay. So we can move on.
Yes, please.
And sorry for that.
Okay.
So I was saying tonight we are going to dig deeper into the issues of children matter.
Yes.
But as I have highlighted, there are many areas that we cover in mediation. It can be succession, it can be labor, it can be commercial, it can be insurance, every other area other than the criminal dispute. So when it comes to children matter, and you have either separated with your spouse or even taken a divorce, the children start to suffer. And in most cases, where such matters are concerned, you get the parents getting so stressed because they do not know what to do with the children. The relationship could be very sour, it could be very violent, it could be very bitter, yet the one parent may not be able to stay with the children and meet all their basic needs. And when that happens, and you go to court, children are suffering, you are suffering emotionally, and the case, as was reported by Madam Daisy, the backlog is quite high. And therefore, if the case is to take 3 years, 4 years, 5 years, and it is not yet sorted out, you can imagine what that will do to your children, what that will mean to you as a mother or to you as a father. And therefore, most of the children matters nowadays are being referred to mediation so that they can be sorted out easily. And you do not even have to wait for the matter to go to court. You can approach qualified mediators for private mediation. It will be cheaper because you will not have to engage 2 lawyers. You only have 1 mediator, both of you, who will resolve the matter as fast as is possible so that life can continue even after the separation or even after the divorce. In such children matters, we normally consider maintenance of the children. How will the children manage to get all their basic needs, which includes food, shelter, clothing, medical care, education, and anything else that a child requires. Now, it is important for the parent to know that when we are talking about children, it is not in the interest of the parent first. It should be in the interest of the child, whatever decisions will be taken, either in court or even in mediation. It is not about you, the parent. It is not about the other parent. It is about the best outcome for your children. And therefore, in mediation, we are going to consider, list down all the issues of maintenance and ask you which one are you willing, or which one do you think you can manage to offer. And in a very respectable way, in a controlled environment where there is no abusive language, no violence, no threats, no intimidation, you get parties are able to realistically look at what they are able to offer and they place it on the table. Other than maintenance, when it comes to children matter, it is also important to talk about the custody. When we talk about child custody, it is in two forms. This is what we call physical custody, which means the place where the child will be residing. The physical place is the child going to the father. Who doesn't get that physical custody gets what we call access. You can get the child, stay with the child at agreed times, agreed days, agreed probably a certain period over the holiday, take them for a sleepover as you will be able to agree upon. But once you have taken the child at the time that we have agreed, you return the child back to the permanent place of that is physical. The other thing that is of importance as legal custody. This child is growing, and as they grow, there are things that they require directions, such as which church, what religion. Other than religion, education-wise, where does the child go to school? Who makes those decisions? If, for example, the marriage was between two different individuals of different cultures, probably a Mukikuyu and a Luo person. Now, this child, is he going to grow in the cultural aspects of a Kikuyu, like circumcision and the likes? Who determines those cultural aspects of the child as they grow? Those are the things that we are talking about as legal custody. And when we talk about the legal custody, the two parents, given the right environment and having the will, they agree upon themselves without anyone being forced into anything, and they are able to determine where the legal custody will be placed. The other thing that we need to do when it comes to the children matter is the access. And as you take the access, we look at the logistics. When and how and where do we do the transition? If, for example, the physical custody is granted to the mother, how does the father get the child when it is their time to take care of the children or to see the child? The communication between the mother and the father on matters concerning the child, what mode does it take? Is it physical? Is it through phone calls only? Is it through text messages? All these things are given into consideration. Now, the most important thing to know is we are talking of a third party, the child, who is not able to speak and say what they want or what they would wish to do. But depending on the age of the child, at times the mediator will ask to have the child not for the child to decide what they want, the feelings, and even the thoughts of this child, so
Oh no.
that you can be able to guide the parent
Okay.
in
All
the
right.
best interest of the child. And therefore, our fellow participants is that.
Okay. All right. Nancy, I think there's very poor connection on your end. It keeps on breaking and coming back and breaking. I don't know if you're in a position to just summarize on the interest. I think you've stabilized now. You can just summarize, please.
Okay, so my friends who have joined us tonight, mine is to encourage you that if you have any issue, any conflict that might endanger your relationship with your the better half, instead of rushing to court, seek services of mediators. If you are not able to reconcile, if you are not able to heal the relationship, at least for the best interest of your child, you will get the best outcome from engaging with a mediator. Thank you so much. I wish you the best. Thank you.
Thank you. Thank you. Thank you very much, Nancy. We truly appreciate your input in this. Unfortunately, it has been a journey because the network was falling off and on and off and on, but we have tried to catch up to listen to what you're saying. Basically, in summary, I will just try and highlight what she was meant to cover, but could not be able to get to it because of the internet challenges. If you are in dispute with the father or the parent or the mother of your child and you are seeking child custody, today's topic is about winning in mediation. Winning in mediation. So how do you become a winner as you're trying to pursue mediation? And one of those things that is very important for you to know is to understand the interest, your interest first, and the interest of the partner. Your interest and the interest of the partner. Now, there are several types of interests that are supposed to be, you should understand for you to be able to work out things amicably. And there are three. There's one that is called substantive interests. Substantive interest. There's another one that is called emotional interests. And there's the last one that is called pseudo-substantive interest. Now, I will just brush through the interest quickly. So if you have your pen, but just it is better to understand than to write them down because we will share the PDF with all of you. Now, for substantive interest, these are things that come out as materialistic. I need the car, I need the house, I need our marital property, I am fighting for the money and all that. That is what they are called materialistic interests. They're called substantive interests. So within yourself, when you soul search, are you looking for materialistic interests? And is that the objective? Then you need to be clear with yourself so that you can also understand your partner. Is your partner looking for materialistic interest or not? Then there is that is called emotional interest. Ulinitukana. Oh, he cheated on me. Oh, she cheated on me. And I feel very bad. It really spite me. So I was emotionally damaged. And that is an emotional interest. So all you need, you don't need the money, you don't need the property, you don't need nothing. All you want is your peace, and you're just emotionally hurt and you want to deal with it. So you need to also be very clear with yourself. Is it an emotional interest that you have? Or is your partner basically going through an emotional challenge? It has to be very clear for you to be able to be on the winning team in mediation. Then there is that very cunning one that is called the pseudo-substantive interest. And the pseudo-substantive interest is an emotional interest that hides itself in substantive interest, in materialistic interest. And I'll give you an example. If I cheated on my wife and she was coming for me with, I want the property, I want ABCD and all that. And deep down, she knows if I just said I am sorry, all that issues, all the pursuits about the money, the property, just relaxes and she says, and hata sitaki mali yako. I don't want anything. Don't even worry about anything. Amesema sorry and I've forgiven her. And that is a very, very interesting part of it. Interest that you need to understand and be clear. Let them be clear within your heart that these are my interests, and also try and assess your partner and know what are the interests that they could be pursuing. That will not happen. Mediation will not work if you do not understand those things. So the moment you have understood them, then you come to mediation and you guys are talking and we are able to get into an agreement, a settlement agreement, just like Dr. Alice was pointing out. You come to a settlement agreement. Then from that point, things will work and it will be easy to move on with your life, and your children will get what they need. Right. Having said that, it is important to note that we match mediators to if you have a dispute and you need to be matched to a mediator, please just let us know and we'll match you to a mediator as soon as possible. But why need a mediator? Why should you get a mediator? And the bishop is here to let us know about why we need a mediator. Bishop, karibu sana. Don't know if you can see me, just hold on a minute.
Yes.
Karibu sana, Bishop. Yes, excellent.
Thanks so much, and good evening, everyone. Allow me to be somehow quite brief because of the time, and I'm expected to be TV very early tomorrow morning, and also preparing for the services. So allow me just to be very brief. Samuel Maderi, Bishop of Overcomers Evangelistic Ministries. I'm also an international accredited mediator based in High Court, Mirimani, and also I perform in Thika, Uthaya, Kilowea, Nyeri, Machakos, Kianyaga, that's Geshogo. Let me say on the mountain side. Deal more on succession matters, commercial, civil, tax, banking, and family and other matters. I'm also a trainer of mediators. Let me try to add on what my colleagues have said on why look for a mediator. One is because of the time spent in litigation. Because when one is in court, you spend so much time, a variable time, but in mediation, especially for court annexed mediation, we are only given 60 days to finish up the matter, and the addition of 10 more. And and even if it's also private matter, it doesn't take long. So because of the time aspect is one of the aspect or one of the issues that can help you to choose mediation. Two, is cost effective. I was dealing with one matter in High Court, Milimani, that had stayed in court for 32 years. I dealt also with another matter in Kirowoya that has taken 37 years. So as much as they are taking long, they are also costly. So because of the cost effectiveness, one may choose mediation. Number three is because of the win-win aspect. Though there are some concessions one will make, at least there will be the talking on both sides, and because of that, it is not adversarial. You do not leave or get out of the mediation suit or praise as enemies. Somehow, because of the talk, the anger has regressed. And two, a mediator is a third party, which person is neutral, will help facilitate the negotiations of both parties. And this mediator also have skills that you help you steer the process to help both parties arrive at a convergence and to arrive at a negotiated settlement. And this could be, there could be some concessions that I have said for both sides, and maybe minimal, but it is better than the costs involved in litigation. The mediator also helped to draft the agreement on mediation settlement, which both parties have to go through, and then after the consenting, it is taken to court for adoption. It now becomes a judgment of the court, and if one party is in default, then the court can enforce. So basically, why choose a mediator is because it is less cost effective, there is win-win, and also there is a time spent. So because of all these reasons, I think it's better for one to choose mediation. That is if you have a matter. So whether one colleague, I think it's the Madam Daisy who said, if you have a court, a session that is a case that is going on, one can ask the judge for the case to be deferred to mediation. Alternatively, you can also withdraw and go for private mediation. But what is easier is for you to ask the judge or the magistrate to take the case for mediation, which is court annexed mediation. Lastly, my name is we as mediators, certified mediators, and we also trainers, mediators. We also do mentorship to our trainees who have gone through our training, plus also those who have not gone through, not our institution, but even in others, have gone to Milimani Court and have found other trainers waiting for me for mentorship. So we do offer. In mediation, there is what we call the mediation process. We take you through, for those who come for training, we take you through the mediation process. And also, in some areas, we also see or check on how culture, power, and gender, they affect mediation, because we do not live in isolation. All those are covered in our trainings. And let me say, we'll also guide you through after the training on how you can be accredited. So other issues we may discuss, especially when you are, how do you do an agreement? How do you write an agreement? How is it signed? All those are the issues that we can discuss during the training sessions. But in a nutshell, I would say, if you are there and you are thinking of how your case can be, or maybe you know somebody in the neighborhood who has a matter, maybe has taken long in court, I think the best ADR you can choose is mediation. With that, I will appreciate you. If I sign off, Mr. Director, maybe it's because I have some issues that are waiting for me tomorrow. I really appreciate all the participants. Have a blessed night.
Excellent. Thank you so much, Bishop. We wish you the very best, even as you will be doing your program tomorrow morning at Inoro TV. Is it Inoro TV or Inoro Radio?
Inoro TV at 8 o'clock.
Inoro
8 in the morning.
at 8 o'clock. Please be sure to join in and join the Bishop at Inoro TV. Now, in summary, I will simply summarize what he has said. And Basically, you need a neutral party. You need somebody who has the best at heart for your interest. And that is none other than a mediator for you to win any matter in court. I mean, for you to win a conflict, you need someone who is neutral, someone who can listen to you with their heart. And from that, anything that you guys are going to deliberate is going to be filed in court. And after it has been filed in court, then it is enforceable, so that if you break the agreement, then what follows can be forced. We know what mkono wa sheria si mfupi, gets there. So yes, you need a person who is on your side and thinks and wishes you well. But then again, remember, this person will be neutral. So the outcomes you'll have is a win and win situation. Having said that, if you have a dispute, that you feel needs to be addressed, I will take you through my mediator. I've seen on the charts many people trying to say, I am going through A, B, C, and D, and I need help. So how do I get this help? Shortly, I'll be taking you through mymediator.co.ke. Just a minute. Very good. Now, all you need to do, if you have a challenge, all you need to do is just type www.mymediator.co.ke. I'll repeat that. If you're going through a challenge and you need help in settling a matter, child custody matter, you have heard from professional mediators that they're here and they're willing to help you. Just type www.mymediator.co.ke. And this is where you will land. You will land on a page like this. And basically, the first part that of the website will be to introduce you to who a mediator is. But then again, we are not here to dwell on who a mediator is. We are here to address your pain. What is the pain of the conflict? And most of the time, like you have heard, like Daisy introduced us to the pains of the conflict, we have seen that there is divorce. These are the common ones. There is children or child custody. There is succession or inheritance cases. There is land and environment disputes, business, trade, and commercial disputes. Even Nancy Wairobi really brought this out very well. There is also labor and employment disputes, rent and tenancy disputes. All these are challenges that you could be going through. Or if you have any other, you can click on any other and just give us a brief description, and then we will be able to help you or match you to a mediator. But in this case, we're talking about child custody disputes. So you will click on child custody, and then down there, you will click on continue. From there, you will give a brief description of the conflict. I will just type XXX or no, XX, let me put YYY. So YYY is the conflict. We will want to know, has it been has it stayed longer than 2 years, or is it between 2 to 10 years, or is it above 10 years? And of course, we know when you stay so long in court with a child, it basically means that that child will grow up not having the best life before the matter is settled through litigation. So what we're saying is that your best option would be if you can be able to capture the attention of a mediator when the dispute is below 2 years, the better for that child. So let's say this is the best case scenario and you are below 2 years. And so you will click next. And from there, has the matter been to court? You will click either yes or no. If it has been in court, of course, just click yes. How long has it been in court? You will probably say, we want to say that it is less than 1 year. That's the best case scenario. So you will be required to name the court station. Let's say you will say Milimani. And sorry for the spelling, Milimani. All right, you understand? Then from there, you will click on next. Who are you in conflict with? Please name the person that you're in conflict. My name is Liki, not director. A lot of people meet me on the street and they call me director. So my name is Liki. And then what is the relationship? So most of us like calling us baby daddy or father of my child, or however you will want to call him, or her. It could also be baby, the other one. Then when was the last time you spoke and what was said? The last time we spoke was last month. Yes. And what was said? Of course, at this particular time, it is normally very bitter. So Ali, we'll just say abusive, right? But try to be as candid and as honest as possible. We are not here to judge you. We are here to help you be able to resolve your conflict. Then you'll be required to to share their number. Let's share their number. This is because we shall call them. Remember, mediation is voluntary. So by the time you're calling the partner, we hope that you have assessed their interest and you have been able to try and break those bridges. If for any reason whatsoever that you will want to settle your matter out of court without us, the better. But if you need our support, of course, we are here and we'll help you to support. But most importantly, we will help you to legalize that document called a mediation settlement and file it in court so that whatever we agree together is what shall pass and what is expected to be respected. So apart from that, we would also like to know if there is any person that you both respect. It could be a relative, it could be someone that you both respect. Please name that person. And the reason why we want that person named is because we will also reach out to them and they shall help us co-mediate. It could be your pastor, it could be your MP, your MCA, I don't know, the person that you feel the both of you truly respect. So we will need you to describe your relationship with them, and I'll put here a pastor, and kindly share the mobile number. And please share their mobile number there and then press continue. Then we will ask you, where is the best location for us to mediate? Would you like us to meet physically? Or sometimes we found many times you find one partner is out of the country. And then we are not able to really sit down and deliberate physically. Or it would take a long time for that partner to get back to the country. So maybe a virtual settlement, a virtual mediation would work best. So just click on virtual. Of course, here, then it would be nothing. You're in Nairobi or Mombasa or Kwale, you can just indicate there. And then you'll click next. And here you will write your name. So this is probably Miss or Mrs. or Mr. Your email address and your telephone number. And then you will click on submit. Once we receive this document, this form, we will sit down and analyze it. Let's say if you said you're in Mombasa, we will find mediators that are stationed in Mombasa that can be able to attend to your matter in the earliest convenience. If you're in Kericho, you have seen that we have our foot very widely spread. So we want to help. We want to get you help as soon as possible. Other than that, we are also training mediators. It's a two-way traffic. We need people who are in dispute to be helped, and those people who want to train and practice mediation to help others. So if you need to become a mediator, as you have heard, is that we'll come and we'll train you, we'll give you a certificate, and then after the training, you'll be required to find an attachment or a mentor. All these of our trainers are mentors who will give you mentorship for free. The reason why you need to understand, to go through mentorship is to understand the process, the judicial process. How do they receive cases from court? How do they get them to their table? How do they help parties resolve their disputes? And how do they file these matters back in court? And then from that, for every matter that you solve, that comes from the court, it will not be charged to the client, but judiciary takes care of mediators. So we are paid a sum of 20,000 shillings per matter that we help, per matter that we solve. for anyone who, then after that process, after the mentorship, you will apply to a judiciary body called Mediation Accreditation Committee. This is the body that governs all mediators in Kenya. They give us a special number to practice. And of course, you need that special number to start practicing and to start receiving matters from court. From that point, you will start getting cases as well from the region where you are, from the different court stations of where you are. Apart from the court annex mediation, there is the private matters. These are the ones that you're trying to sensitize on this meeting. And what we are saying is that if you have a matter, please fill up mymediator.co.ke and we will match you. This matter has not, if your matter has not already gone to court, we'll match you to a mediator and they will be able to help you file those matters to court. So that is private mediation. Apart from that, I do not think I have any other thing to say, but appreciate all of you for taking an excellent 1 hour, 14 minutes to be with us. I can see, don't know if there is anybody who can close with a word of prayer. So our connection points, please remember www.mymediator.co.ke. If you want to train as a mediator, please click on www.mediationafrica.org and you'll be able to connect with you. Other than that, you have numbers, you have our numbers, our office lines. Please get in touch. We need a volunteer for a word of prayer to say good night. We wish not to take so much of your time. In attendance, we've had a wonderful, above 200 people who have joined us, and we are grateful for allowing us to spend this evening with you. Asante sana. Maybe Dr. Alice, you could lead us in a word of prayer.
Okay, let's pray. Dear Heavenly Father, we want to thank you this evening. Jehovah God, you've taken us through the webinar. Jehovah God, we want to thank you for the participants. Thank you, Jehovah God, for having given them the interest even to be with us. We pray, Jehovah God, that you will keep ministering to them and that Jehovah God, they will do the needful so that Jehovah God, they can join us in the trainings or in the mediation matters that they could be having. Jehovah, we commit them all into your hands. And as for the trainers, Jehovah God, we pray that you continue energizing us and our director as well, so that we can continue with this job, honorable job of mediation, which is peacemaking, that Jehovah God, we shall make this country a different country altogether. Jehovah God, we commit the mediation matters into your hands as the court, Jehovah God, tries to pursue and to see that matters are handled in this way. Jehovah God, we know the court matters have been taking so long. Jehovah God, that's why we are praying that Jehovah God, you open this avenue for as many people as possible so that we can be able to resolve the conflicts. We praise you and we thank you and commit every one of us into your hands. And we pray that we shall have many more opportunities to meet. In Jesus' mighty name we pray and believe.
Amen. Thank you very much. Have a lovely, lovely evening. Have a blessed one and peace be unto you. Asante sana.